The subject of today's blog is wrongful death claims in Massachusetts, and I recognize it's an unfortunate subject, but one legally we have to visit from time to time. Wrongful death claims are a creature of statute, and in Massachusetts it's Chapter 229, Section 2. And without getting overly legalistic and specific, I'll try to point to you some of the key features of that Massachusetts law. The first is you have a right to recover for the decedent's pain and conscious pain and suffering, and that becomes part of the probate estate. That becomes an asset of the probate estate. But the death claim is not part of the probate estate. The assets do not go through the probate estate, and while it's brought by the personal representative of the decedent, who might be known as an administrator or an administratrix, and is appointed by the probate court, the money doesn't go back into the state. It goes direct into the estate. It goes directly to the statutory beneficiaries. And the statutory beneficiaries are listed in Section 1 of Chapter 229, and they are what is known as the presumptive takers. The fact that wrongful death money does not go in the estate can be a very helpful piece of information, because it allows your attorney to avoid medical liens in particular. Liens are claims on the estate for medical treatment, but in a wrongful death claim, since the money goes to the statutory beneficiaries and passes outside the estate, they are not subject to medical liens. And while the lawyer has to still speak to them and negotiate with them, that piece of information, that it is wrongful death money and not subject to the claims on an estate, is a very, very helpful factor. Now, how much each of the statutory beneficiaries receives certainly can vary, and there is case law going back in the 1970s that reflects a difference in an award between a mother and an absentee father, and that has to be looked at with the specifics of the particular case in mind. And what kinds of things can the statutory beneficiaries recover? Well, there's the tangible damages, which are the reasonable net income that the decedent would have provided the statutory beneficiaries. There's the costs associated with the passing. And then there are the intangible benefits, which are comfort, society, support, assistance, and advice that the decedent would have provided the statutory beneficiaries. There is also a provision in our law for punitive damages. All that provision says is that it can be awarded in an amount not less than $5,000. Punitive damages arise in a wrongful death claim if there has been gross negligence or reckless, wanton, willful disregard. And again, the only dollar figure given in the statute is an amount not less than $5,000. But the principle to remember is it is designed to deter the kind of conduct that the defendant engaged in. And even a look at the assets of the defendant is relevant to the punitive damage complaint. Now, some have tried to argue that comparative negligence should not come into play in a wrongful death action, but a defendant will be entitled to point out that the person who passed away, the decedent's own negligence, comes into the consideration of recovery, and that is something that cannot be avoided. So there are specific facts to keep in mind with this creature of statute that is put forth by the Mass legislature, and every state has its own wrongful death statute, and they do in fact differ in some noticeable ways. But I think I've touched on the outlines of the major points in the Massachusetts wrongful death statute. Thank you.